Hi everyone, we're going to talk about past relevant work, and that's PRW as we refer to it. That's step 4 in the 5-step analysis. So recall step 1 is there SGA, right? Which means are you making more than one, as of 2021, are you making more than $1,160 per month gross income? Step 2 is the, and for step 1, if the answer is yes, right, you're not disabled. If no, you move to step 2. Step 2 is the impairment severe enough, right? That means it's going to last 12 months or more. Then if no, right, then it's over. If yes, you move to step 3. You analyze if it's a listing or not. And then if you get past that, if you satisfy the listing, then it's done, right? You won. That's a tough argument to win, though, typically. So you generally move to step 4, and step 4 is, can the claimant do past relevant work? If they can, they're not disabled, and the burden is on the attorney for steps 1 through 4. So what is past relevant work? How is it defined? It's a 3-part test. This is all conjunctive, right? It's all ands, not ors. The work must have been substantial gainful activity. So you actually made enough while you were working there for it to be SGA. It was performed in the 15-year relevant period. That's 15 years prior to your alleged onset date. If it's outside of 15 years, it's not SGA. It's just too old. And when you had the job, you did it long enough to learn it, right? You learned it to reach an average performance. You didn't quit 2 weeks in, and it was a job that required a lot of training. So that is what past relevant work is. You made SGA, it was within 15 years, and you performed the job long enough to reach average performance. Now, so again, this is step 4 of step 5. So can the claimant do past relevant work? If yes, they can. Analysis ends. You've lost the case. The client is not disabled. Step 4 is a function by function comparison of the claimant's RFC and past relevant work. And that's completed at step 4. Age is not a factor here. Education is not a factor here. It does not matter if the company your client worked for burned down, went bankrupt, moved to China. None of that matters. All that matters at step 4 is if the claimant's RFC is such that it would allow him or her to perform their past relevant work. So if their RFC is light and all their past relevant work is sedentary, they can perform that past relevant work and they are not disabled. Now there's actually 2 parts to past relevant work. One is, can the claimant do the work as actually performed? Right? Can the claimant perform past relevant work as it was actually performed? So in other words, as they actually did it at their old job. So pro tip, and I get into this more later in the hearing, later in the class, but you always ask the claimant at the hearing, and CL means claimant, if that's not clear. Always ask the claimant at the hearing, what's the most you ever lifted at that job? So if they lifted 50 pounds there one time, or, they were a registered nurse and they had to pull this 300-pound patient off the floor with the help of one other person, right? You want to get that number. Was it 80 pounds? Was it 50? Was it 100? Because you're trying to knock out past work. The burden is on you, the attorney, and your client to knock out past relevant work. And the other part of past relevant work is not merely can it be performed as actually performed, but could it be performed as generally performed? As generally performed means as performed in the national economy. And really, this is where the Dictionary of Occupational Titles comes in, which we talk more about later, that the vocational witness at the hearing will use to say, this person, their last job was as a medical assistant, and that was performed as follows, blah, 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 blah. And they'll essentially pull that directly from the Dictionary of Occupational Titles. So we'll talk more about that, but that's past relevant work. So there's 2 parts. Let's go back to the beginning, right? The definition. That's the 3-part test. Was there SGA? Was it performed in the 15-year period? And did they do it long enough to actually learn how to do the job? And then the 2 steps for determining past relevant work are how was it actually performed, and can the claimant perform the past work as actually performed, and how was it generally performed, right? Can the claimant perform the job as it was generally performed as it's described in the Dictionary of Occupational Titles? So the job could have been described as light in the Dictionary of Occupational Titles, but it might have been as performed as medium. So, you know, we'll talk more about this, but those are stones you want to make sure you're rolling over. And so, again, to see what the claimant, if claimant can perform past work as actually performed, that's why you ask them, you know, what's the most you ever had to lift while you were there, even if it was just one time on one day. And so that can knock out past work as actually performed. Now, a couple of things to remember. Again, steps 1 through 4, the burden is on the claimant, right? And you're the attorney, so it's on you, of course, right? So past relevant work is step 4. You have to knock it out. When it goes to step 5, that's when the burden shifts, and now the government has to prove there are other jobs the claimant could do out there, and that's where they get testimony from that vocational expert or vocational witness. And, you know, knocking out past relevant work, we'll talk about that later in when you're dealing with the claimant and asking the claimant questions, as well as dealing with the VE. But one way to do it is to show the job was a composite job. And a composite job is when it's a job mixed with other jobs. So it could be where you're a bartender who also has to do some heavy cleaning around the bar. It could be you're a nurse, but you're also doing some payroll at the place you work, because it's a smaller facility and they need people to do more than one thing and wear more than one hat. Composite job doesn't guarantee you're knocking out past work, but when you do that, it's harder for them. It's harder to show that they could do past work. It's easier to show they could not do past work when the job is a composite. And the most ever lift, right, that question is designed to show how the job was actually performed. And so it doesn't matter, you're not asking about the average weight they lifted on an average day, you're asking about the most they ever had to lift, even if it was just one time while they were doing that job. And so, and again, you're doing that to knock out past relevant work as it was actually performed. That's the point of the most ever lift question. So that's past relevant work. Know the definition, know that it's step 4, and we'll talk more about knocking out past work, but I think you get the gist of it here today. So that's the basics. We'll see you in the next lecture. Stay tuned.